Assalamualaikum warahmatullahi wabarakatuh. My name is Wina Warviyani Sukarna and my NPM is 17 51035. In here I would like to tell about international law, a material of international law, and the first material until the last material. Thing is, what this means international law. And international law, there is two approach. The first approach is a modern approach, and the second one is the traditional approach. And the modern approach is the legal entity governing the activities of entities that have an international personality. That's to say, the scope of international law is not only in the country, but the relationship of relation with organizations associated with other countries. So there is a difference between the nation of international law and science limits. And the second one is a traditional approach. Traditional approach is the conduct and relationship of state. The meaning is that the understanding of international law, the meaning in the past only limited the relationship between one country and another country. The second one meeting is about law and international system. And in here, there is a question: is there a relationship between international law and national law? Before that, there is a theory regarding the relationship between international law and national law, and same like what is the meaning of international law. The theories regarding the relationship between international law and national law, there is two approach. The first one is monism approach, and the second one is dualism approach. Monism approach, there's international and municipal law as a single legal system, and then legal regulation as a single legal system by states and individuals. And the dualism approach is international and national law are distinct legal orders. They are not part of unfight world. So, the application of monism and theory the application of monism theory in a national court is treaties, convention, and the order of international organization are applicable or effective without any action being required to convert international law into municipal law. That means international law automatically there is national court. And the application of dualism theory in national court is national court may only apply international law when the law has been incorporated into national law, or when the court incorporate international law on its own motion. That means international law adoption or incorporation national law. So national law can choice he want to follow the international law or not for a national law. The third meeting is subject of international law. The subject of international law is state, international organization, holy throne, individual, and belligerent. The first one of a subject of international law is state. The state is subject of the former international law. The state as a subject of international law must meet the following requirements. One is a permanent residence, specific territory, a government, independent and sovereign, the ability to establish relationship with other countries. And the state subject of international law has the following obligation: do not maintain complaints within the territory of another country. The territory of another country, not allowing its citizens to take action that require the freedom or supremacy of the other territories. Each country is obligated to engage in activities conducted within territory against another country. No domestic interference. The second one the subject of international law is Holy Throne or Vatican. The Vatican is a relic of the Pope as head of the Roman Church, who has worldly powers. The Vatican, as the subject of international law, signs the treaty between Italy and the Holy Throne of July 11, 1929. Third, and the third, the third one of subject international is international organization. Organization whose members consist of states have a significant membership and have a structure of organization. For example, like PBB or UN is belligerent. Belligerent can say belligerent if the group of people make an action to separate themselves first from the sovereignty of a state, and they possess half of national territory and real authority. According to the law of war or belligerent, rebels and parties to disputes may be used as parties to disputes, including 1. Have the same right to determine their own destiny. 2. The right to freely choose their own destiny. The right to freely choose its own economic, political, and social system, and the last is the right to control natural resources in the area itself. And the last subject of international law is of individual. Individual is a person or citizen is a subject of international law. The last meeting is 5 jurisdictionally principle. There is the territorial principle, nationality principle, passive personality principle, protective principle, and the last is universalitas principle. Then maybe Jasil is learning the beginning of the meeting until the end of the meeting. And I would like to express thank you and wassalamualaikum warahmatullahi wabarakatuh.